Hi, I wanted to welcome you to the Divorce Planning Podcast. I'm Carri Goldring, and I'm in the mortgage business, and I do planning pre-divorce for people who are either going to refinance their home, do an equity buyout, or plan to purchase a new home and make sure that everything in the divorce decree is worded properly and the numbers in the planning is taken care of so that you can go through the underwriting process smoothly. And I would like to introduce you to other people who are interested in the divorce planning process so you can get a real education of what's involved. Hope you enjoy.
Hi, today I have with me Max Emmer, who is a family attorney, and we're going to go over just the terms that attorneys use really when they talk to us, and we don't understand half the time what they're saying, Max. So welcome.
Thanks for having me, Carrie. It's great to be here as always. And I think what you're saying and what you're doing is really smart. I do think us lawyers are guilty of either assuming or expecting clients and people to know what certain vernacular and terminology means where they'd have no reason to know that. And I know I'm guilty of it. And I think some of us do better jobs than others of kind of, explaining in layman's terms or watering down or at least telling people what to expect. But I definitely think we could go over a few terms and steps in a typical case and kind of talk about what they mean, what to expect, and how most of the time it's not as daunting or as intimidating as it might sound.
I would love to do that. And I don't think it's just the attorneys. I think it's every industry, right? Every
Yeah,
industry has their own language. We all talk our own talk.
absolutely.
And when we're all together, that's great. But when we're talking to people who don't know, and then I'll have people, when I'm talking to them, say, oh, well, I have a settlement conference coming up, but I don't know what that means. Or I have mediation and I don't know what that means.
Yeah.
So if you could walk us through a typical case and use your lawyery words and
So
explain.
yeah, you know what I'll do is, and I'll try and do it and balance between getting too granular and also say, because there's probably 40 terms we could go over. But I
Right.
mean, if we start with the basics and interrupt me or chime in or, divert me if there's any terms you want to talk
Perfect.
about or don't talk about or I don't cover. But really, if you start at the beginning of a divorce filing, the first thing you're probably going to hear is the idea of a summons and complaint. And those are court pleadings, those are written documents that your lawyer prepares that start your divorce case and are filed with the court. Generally speaking, the only thing you'll have to do with those is review them and make sure they meet your approval and the information's accurate, and you'll sign them. But when you hear your lawyer talking at the beginning of a case about summons and complaint or responsive pleadings, just know that those are the court required and mandated forms and documents that are prepared and filed to start and respond to any divorce case. And
So even if
if
you're not complaining, it's still called
yes,
a complaint.
and in a lot of cases that I work on and we work on where we refer to it as a petition, not a complaint, that's when if the parties are doing, whether it's a collaborative divorce or a joint petition, instead of there being a complaint with a plaintiff and a responding defendant, the parties are in effect filing the petition jointly and together to move forward with their divorce.
Okay, that's helpful.
And then if we're gonna be a little Oakland County specific, but most counties have similar. I know a lot of my clients, especially if they have children, they tend to ask about what is the friend of the court, what is an EIC or an earlier intervention conference. And what I would say is, um, I refer to with the ultimate respect and deference that the friend of the court is kind of the first line of defense with issues related to minor children, custody, parenting time, child support. And every case is assigned a referee, which I would call a junior judge. And if you have certain issues, particularly around those related to your minor child, they tend to go in front of the referee first. Now, in Oakland County, any case with minor children is scheduled automatically for an EIC or an early intervention conference. And that's likely, unless you're having motions, going to be your first court hearing or court involvement. And the EIC is completely routine. It is very standard. It generally takes about 10 to 15 minutes via Zoom. And that is a brief check in where you and your lawyer will get on Zoom with the referee. The referee will briefly explain how the front of the court works, what their offerings are, and see how the case is going. If your case is not super contentious, you probably won't see the referee again. So every case, especially in Oakland County, generally begins with that. And then the next kind of term you would probably hear is the idea of a settlement conference. And a settlement conference is really a check-in with the court about what's the status of the case, how things are going, and where do we see it going from here. And a lot of times, if the case is proceeding reasonably well, when that settlement conference date comes up, usually the lawyers will get an email from the judge's chambers and say, what's going on with the case? If you guys have settled, are you ready for a final hearing date? If not, are you going to appoint a mediator? Do you have any major issues outstanding? So, since COVID, most clients and lawyers are actually not having to appear for settlement conferences. That's kind of the first formal check-in with the court after the more informal early intervention conference before the rest.
So is it done on Zoom now, or it's not done at
Done
all?
on, so I don't want to speak across the board, but 99% of those um, beginning hearings and check-ins are Zoom if they're occurring. EICs are all via Zoom. Settlement conferences, if they occur via Zoom, especially first ones. If there was an extraordinary circumstance or something, highly in dispute or contentious, but other than that, preliminary hearings in this day and age expect to be virtual.
And then you're going to see your judge at that time?
So typically now, if you have a first settlement conference and you guys are either the case is going well or you're going to mediate, you actually won't have to go to that. And at that time, the court will basically ask your lawyers, are you close to settling? What's the status of the case? If not, have you agreed upon a mediator? And that is kind of where I would say the cases kind of go in two directions, fork in the road. Let's say your case is proceeding very amicably and you've exchanged financial information, and maybe your lawyers you're directly negotiating. Maybe you might not immediately schedule or appoint a mediator. If your case is not that, that is the time where your lawyers are going to discuss a mutually agreed upon mediator and schedule mediation. And what mediation is the hiring of a neutral third party who is a very experienced family law attorney who is going to help facilitate settlement discussions between you and your spouse via counsel on the outstanding or issues in dispute. And mediation generally is scheduled for one session of between 3 and 4 hours. Some mediators prefer to do in person at their offices. Some mediators prefer to do Zoom. But any mediation you attend, your lawyer should prepare you of what to expect. And your comfort will be protected and kept as a priority. For instance, the most common method of mediation is called shuttle diplomacy. And that is basically when husband and counsel are in one room, either in person or virtual, wife and counsel in the other room, and then the mediator goes back and forth to help shuttle and facilitate discussions, disputes, and negotiations with the hope of bridging outstanding gaps to get to a global resolution.
Okay, and that is considered court-appointed mediation?
So that's a very good question. So how it works typically now is the court will require you to go to mediation before you get to, say, a formal trial. And 98% of family law matters settle prior to or at mediation. Very few cases are going to trial. So if your case has not settled by a certain point, the court will ask counsel to agree upon a mediator and to schedule that so at least the case is moving forward.
Okay. But you could always hire a mediator.
Absolutely. Like I'm a big fan of, I would call it early mediation in cases. So
Okay.
for instance, let's say you don't have a settlement conference till 120 days after filing. I have plenty of cases where 20 days in, we say, hey, look, let's pick a mediator and get this scheduled, see if we can expedite this matter. So you and counsel can do whatever you want, but the court will say if you guys have not resolved it by a certain amount of time, hey, you need to pick a mediator and at least get a date on the books.
Okay, so question for you, and I don't
Sure.
want to get too off topic.
Sure.
I think I am, because this might be more mediation related, but I want to make sure the names are all right. So when you, ahead of time, before the judge suggests it, and you pick a mediator, is it still the same type of mediation where you shuffle back and forth and you're
Yes,
working towards a settlement?
the mediation process is the same. And I think if you want, I can make a distinction between mediation and arbitration. Mediation is non-binding facilitated settlement negotiations. In mediation, the mediator has no binding authority over you. They can make recommendations. They cannot force anyone to do anything. Arbitration is more of a decision process where the parties and counsel, if they elect to, they are sending a matter for binding decision before an arbitrator, which is basically a judge that is not a formal judge. It's a private lawyer, professional who serves as arbitrator. So in mediation, the process will by and large be the same. But again, you cannot be forced or compelled to do or agree to anything at mediation. You can show up for mediation if you don't like what you hear. In theory, you could walk out. I don't recommend it. You could get to the end of a mediation session and say, I don't like what's being proposed. Or you could say, hey, we're making progress. We're going to come back again. But
Could you agree to everything and then at the end of agreeing to it, say, forget it, I don't really want to do it?
so how it works is if you reach an agreement at mediation, typically what will happen is both parties, both counsel and the mediator will all gather in one room. And the mediator will record the settlement and ask questions of both parties to confirm they understand the terms of the settlement, they're not being coerced or forced under duress, they want to settle and they want to resolve this matter. So if you reach a tentative settlement at mediation and your mediator records a settlement, then it is binding. Then that is official. But you are not forced to do so. And if you have any hesitation, you should not agree to a settlement at mediation. You should take a beat, talk to your lawyer, schedule another session, even just check back in. But a mediator cannot force you to settle and cannot force terms upon you. Really, the mediator is there to help facilitate settlement discussions and help you reasonably resolve your matter.
Okay. All right. So what other terms are there? Like I'm thinking, I
Like
had
trial date, pro con. So like as we get
what's
further.
pro con?
Okay, great. So I'll take on pro con and trial date. So a lot of people hear trial, and I think trial is a scary word. Trial, you think of A Few Good Men, you think of the movies and TVs. I'm spending a ton of money, we're preparing, we're having witnesses and documents, and that is what trial is. But when you see a trial date on your scheduling order, that's typically a first trial date. And you are not going to be forced to trial on that date. First trial date is kind of a more formal check-in after the settlement conference. And if you haven't settled yet, the court's going to want to know, well, why haven't you settled? What are you guys doing about it? What are the key points of dispute and disagreement? And usually at that point, the court will schedule what's called a firm trial date, and that would usually be a couple months out, where the court would say, hey, look, you guys should still try and settle. You need to finish discovery. You need to finish what you're doing. If you don't settle this in the next couple months, I'm not going to let this case go forever and we have a firm trial date, but try and get the case done. And most cases are. Now, let's say you settled your case and you hear the term thrown around pro con, and that is one where I know in particular I throw that around as if all my clients should know what that means. Every divorce in Michigan is finalized with a final hearing before your assigned judge. And that final hearing is called a pro confess or a pro con hearing. And what that entails is um, if both parties have counsel and you have an agreed upon settlement, only the plaintiff and counsel have to appear. Defendant and counsel are absolutely allowed to appear. But if one party doesn't have counsel, they also have to appear because the judge has to ask them questions. And a pro con hearing is when the court or your lawyer asks you a series of statutory questions to confirm your understanding of the settlement, to confirm that you don't want to go forward, you know you had a right to trial, you're waiving that right, you know you could have gotten a substantially similar, better, or worse result, you understand the provisions related to custody, parenting time, child support, spousal support, and with all that said, you are asking the court to finalize your divorce and enter a judgment. Um, those hearings tend to be quite routine. They are virtually, no pun intended, all on Zoom now. Again, that hearing can also take 10 to 15 minutes. It really depends on your court schedule and their docket. But a pro con hearing is kind of that last final step where you make statements on the record before the court so that they will finalize your divorce, enter your judgment, and conclude your case.
Okay, but that doesn't mean someone is divorced after that is over.
No. So with your pro con, if you have a signed judgment and you can let's use the calendar to make this easy. Let's say John and Jane and their lawyers signed a consent judgment of divorce on June 1st. They filed it with the court. Let's say they had a pro con hearing on July 1st, 2025. They all appear for the pro con hearing. It goes through, the court is satisfied with the burdens of proof and everything. The court will then finalize it and sign the judgment. So let's say you have your pro con hearing July 1st and the judge signs your judgment of divorce July 1st. Your effective date of divorce would be July 1st. Let's
Okay.
say you have the pro con hearing on July 1st and the court signs it July 3rd. Your date of divorce would be July 3rd. So generally, they're either the same day or within a couple days of each other, unless there's missing paperwork or something. But once you get to the step of a pro con, you are finalizing your divorce in the coming days.
Okay. All right. That is very good to know too. I know that comes up on the mortgage when we ask somebody, are you married or unmarried? And they're in the middle of the divorce and then they're like, oh, I don't know how to answer that. And
100%. And what I would tell people is you are married and things are marital until you have a pro con and you complete that and you have a signed and dated judgment of divorce from the court.
that's
Until
exactly
that date, you are technically and legally still married.
right. And we say the exact same thing. So that's good that we're all on the same page for that. So we do it the same. And I won't ask to see a judgment of divorce until it's signed by the judge. And if you close married and you haven't signed a divorce judgment, then you're not divorced and we don't ask.
No, I mean, until that is one thing that I try to be explicit about. And, I think a lot of times people are like, oh, well, once we sign, it's all done, or once we meet it, it's all done. And yes, in theory, you've reached a settlement, but until you go before the court and they approve and sign it, you're married. And I think there can be both minor and major issues with that, financially, logistically, legally, whatever it is. But yes, it is important to err on the side of caution and to emphasize that unless and until you have a pro con hearing, the judge approves your judgment and they sign it and they return it to your counsel and you, that and only that is your official date of divorce.
Right. And it seems so like anticlimactic that I think a lot of people are just like, wait,
It is very. I can say, as someone who did 3 pro cons in June, clients seem to universally either be, I don't want to say disappointed, sorry. I think they expect it to be a lot more pomp and circumstance, or just have different expectations. But I view it as I want my clients to be as comfortable and prepared as possible. I'd rather them think it's anticlimactic than think it's climactic. Because if it's climactic, I either didn't do my job or something's gone awry.
I think it's kind of like, how when you get married and they're like, okay, you can now kiss the bride.
Yes.
And then when you're divorced, no one says, okay, you are now divorced.
Yeah, no. I mean, and I think certain judges, kind of have a nice speech or kind of soliloquy they give. But yeah, I do think you're right. And I think a lot of people, and I know this, and I know clients who are very nervous for it and they think they're going to have to answer very personal, invasive questions. And I think I overlook that because I do this all the time, but that's a perfectly reasonable, expectation. Like I had a client once and she was very nervous, like, was she gonna have to talk about details? And, one thing I always tell people about a pro con, we are required to ask of any woman on the record at your pro con upon information and belief, are you currently pregnant? I have asked 80-year-old women if they are pregnant, which clearly I believe they are not biologically. But that is one thing when I have a female client is I always give them that as a heads up. Not that I think it's a big deal, but I've had clients who didn't know and they're kind of taken aback. So because if you were pregnant, there could be a question and issue of future custody. With any woman, we are confirming on the record that upon information and belief, you are not currently pregnant. And that is a standard routine question, even if you think it is not relevant or plausible.
Right. I could definitely see where people would be like, why are you asking me that?
Exactly.
But
Yes.
it is an important question. Well, I thank you. This went super fast. I mean,
Yeah, it's we knocked some terms down.
we did. And I really appreciate it. And I think I'm going to start writing more terms down, and maybe we'll do a part 2 when this
Yeah, and
comes
if
up.
And if you wanna, if you ever have any questions, Carrie, you know how to reach me. And yeah, I think any person thinking about or starting the divorce process has an absolute right to feel educated and engaged and informed about how the process works, what options are available. And so, my recommendation is talk to a lawyer who makes you feel comfortable, who makes you feel heard, and you deserve to know what's going on, what to expect. And look, are we mind readers? Can we predict everything with a silver bullet? No. But at the very least, you deserve to know what to expect, what's coming down the pike, and how to prepare and manage that.
Thank you. That is very true. Tell us your phone number or website, so if people want you, they can find you.
Sure. So my website is www.emmerlawplc.com. My email, max, M-A-X, at emmerlawplc.com. My office can be reached 248-859-0015. And what I would say about me is I think I help people do divorce differently, and I really try to help people curate a process and a plan that works for them and their family, not just putting them on a one size fits all assembly line of divorce.
I agree. You are definitely very passionate. There's
Yeah. Well,
no
thank you, Karen. It's
no
it's
doubt
good to
about
work with
it.
great colleagues like yourself too.
Well, thank you. I agree. And thanks for your time. I know you're in a hurry, but I really appreciate you.
Oh, my pleasure. Anytime, anytime. Happy to be here.
Thank you.
I hope you enjoyed the podcast. I'm Carri Goldring, and if you ever have any questions regarding mortgage, feel free to give me a call or send me a text message, 248-420-4524. Hope you enjoy the rest of your day.